Alternative Digitalk. Real issues, real talk.
Fellow citizens, following the sequence of events, Uganda seems to be at political crossroads.
I'm not a servant of anybody.
Madam, I know the law.
As such, Alternative Digital brings you the Interface Show with retired Colonel Dr. Kiza Besuje.
Let's keep on the same page on Alternative Digitalk,
As he gives you the alternatives on the transition question, rule of law, human rights and freedom, youth inclusion in governance, economic stagnation, as he confirms.
I'll be always here Saturday from 10 a.m. in the morning. Be there.
Don't miss the live discussion on the Alternative Uganda, Digitalk TV Facebook pages, and the Alternative Uganda YouTube channel.
Our viewers, good morning. My name is Mohammed. We are streaming live on our social media pages, that's the Alternative Uganda and also Digitalk TV, and later on our YouTube channel, the Alternative Uganda. So that means we are streaming on 3-in-1 social media handles. Today, as a norm of every Wednesday, we are blessed to have Justice Kanyeihamba to take us through lots of legal related issues and also governance and democracy at large. Justice Kanyeihamba, say hello to our viewers. And
Hello, viewers. Nice to be with you again. It's very, very bright here in Buziga, and I'm very delighted again to be having a discussion with Norman on the state of governance in this country, and in particular, the law and the justice.
Thank you, sir. On a lighter note, I think good years ago, and having spent most of your time in Europe, were you celebrating Valentine's Day those days? Because as I understand, yesterday was Valentine's Day, people were putting on red, carrying flowers here and there.
Yes.
How was it like?
I sent flowers to my wife through my son, so she got her Valentine flowers yesterday. And this day, or yesterday,
Yes.
is negotiated in remembrance of one of the reputed great lovers of the world. He was called Valentine. And they say he was a very handsome man, attracted by any woman who saw him. And he had a lot of adventures with women. I don't go into details. And because of his conquests and his love for the opposite side, the English, I think, decided to name a day in the year
14th February.
against his, rather in honor of his name and adventures, and they called it Valentine.
Okay, young people you have heard, for me I had thought it's for the likes of, as you see them, those young people there. So I had thought it's for young people, but if you...
every younger person should have a Valentine.
Okay.
And those of us who are married, our wives are our
Valentines.
Valentines. But I know men who have several.
So those become Valentines. So do those become Valentines then? If you have several. Okay, colleagues, you have heard from Justice Kanyeihamba on how he was able to send the flowers to his dear wife, who resides in UK, and that's a good one for those of you who either got disappointed or appointed yesterday. Yeah, so it's life. Those I'm told on social media that those who were checked yesterday, there are those who were, you know, you want to surprise someone, then you get surprised instead.
That's right. It's not too late. They can still send some Valentine's.
Okay, we started on a lighter
No
note.
one is still with us.
Okay, started on a lighter note, and that will now take us into the entire sequence of some of the events that happened previously. But I want to begin with what is fresh, and that is in regards to your colleagues, two honorables, Ssewanyana and Honorable Ssegirinya, whom your petition literally was so much to defend them in regards to a right to bail. By God's grace, yesterday they were granted bail.
That's right.
But I want to give you a brief preamble that last week the DPP, Justice Jane Francis Abodo, appeared in Parliament, and she said that the Directorate of Public Prosecution was ready and had its evidence on table and was very willing to proceed. Days later, the same DPP's office wrote to court with a no objection in regards to the application of the accused's bail. What does this mean? Where DPP is ready to proceed, would lawyers continue and apply for bail, or it would be the other way around, that you want to expeditious hearing and you have that sorted straight away?
Obviously, once the DP is ready to proceed, the accused or the prisoner is immediately taken to court and the trial begins. So there is no need to talk about bail anymore. I heard the accused talking about their release, as if it was very, very important. They didn't even mention me. That when I was pursuing the protection of the right to bail, I met him at the court with their lawyer, Lord Mayor of Kampala, Lukwago. We had a chat. Yesterday, they neither mentioned Lukwago nor Kanyeihamba. They seem to imply that President Museveni is a threat to the right to bail. But you know, we challenged him in the Constitutional Court on the right to bail, and he withdrew from his threat. And I even thanked him for being a statesman and a lover of his country. That is on record. But these younger people, I forgive him, they've been in jail. The world has passed them. They didn't know what they were talking about. They should have thanked Lukwago for having been with them all this time, applying for bail in different courts for them, and not his name was mentioned. But as I say, I forgive them because they've been out of this world. They don't know what's been happening.
Okay.
Museveni, President Museveni, is no longer a threat to the right of bail because he withdrew his threat in 2020, in 21. This is more than 2 years ago. So how do you continue saying is a threat to bail? So I wanted to correct that and to say what we have said, to emphasize. Once the Director of Public Prosecution is ready, the question of bail does not arise anymore. Unless, of course, the court adjourned the court and they were a dangerous criminal, bail does not arise. You go back to detention because you are dangerous. If I like the MPs, like these two ones, who were loved and elected by the people, and accused on a crime, most of I think seems to be bogus. Because how does younger people like Ssewanyana and his colleague kill an old woman of mine for political reasons.
Who are not in their
It
constituencies.
doesn't make sense, in my opinion. They could have called their opponents of the NRM or their opponents in the constituency.
Not in Greater
But
Masaka.
you go and they conspire to kill an old lady, an old woman, and you are jailed indefinitely without bail because of that. So let me tell you what is wrong with Uganda. They start something very, very important. And when those who are involved, they divert them to an entirely different matter. The whole of today, those people who have been released from jail on bail have been talking to NBS, talking to everybody. It is in the newspapers everywhere. The crime they committed has been forgotten. Thank you.
I want to ask you, I mean, to depend on your legal expertise, and you educate the viewers the purpose for which bail was introduced, because there should be some theory behind, some principle rather behind why bail was introduced.
Yes.
Either, I mean, as a common law scholar and the rest, because we want to wait vis-a-vis the readiness of the DPP's office. Take, for instance, if I was on remand, I would want bail because the state says we are still under investigations. In the event that the investigations are done, is it also okay for me to apply for bail despite the readiness of the DPP's office?
No, you don't apply for bail. The trial goes ahead immediately. You are tried, the evidence is presented by the Director of Prosecution or by the DPP, and you give your case. And in my opinion, in the case of Ssewanyana and his colleague, that case should just take about half an hour. Because really,
offense for just half an hour.
If we were in a country where they believe in the jury, no jury woman or man would accept the prosecution evidence that these honorable MPs went to Masaka or conspired with the people in Masaka
and butchered the people.
And butchered the people, especially elderly people, for political reasons. The jury would not see, they would spend half an hour and dismiss the case.
This also goes back to you. In your service as a Supreme Court Justice and also, Supreme Court as a Supreme Court Justice, I am sure as the day follows night that you had capital offenses.
Yes.
What is that? I mean, do you have a specific case that you had expeditiously? And if yes, how long would it take?
So
a capital offense like murder, terrorism, and the rest. Most like like the same cases that are being accused against Ssewanyana and the rest. How fast did it take you if we were trying to now bring that principle of expeditious?
We have a big principle which we inherited from the common law that where a case is constitutional, you must decide it as soon and expeditiously as you can. That's number one. Number two, where somebody is charged with a capital offense like murder,
terrorism.
Again, there is this question. We believe in the principle that unless you have been convicted by a court of competent jurisdiction, you are presumed innocent. Therefore, such a serious charge and is brought against the principle or you are innocent until proven guilty, they should be heard as soon as possible. Some of the laws, which I don't particularly agree with, knowing that your innocence is very, very important. Provide that if you have been jailed for either 181 or is it 180 days without trial, you should automatically
Be released.
be released on bail without any question. These people have been in jail
For more than a year.
for more than a year. So whoever is the director of public prosecution, whoever is responsible, the Minister of Justice and Attorney General, or whether
Constitutional affairs.
whoever is the Attorney General, is breaking the law and defying the Constitution of Uganda.
Maybe you need to substantiate more. That principle, I want to believe by the time you people made the Constitution, most likely, and I don't want to plant words into you, but you would substantiate. It's as if you meant that so as long as one hasn't appeared in court for that period of 6 months, it becomes an automatic release.
That's right.
But the excuse that the DPP had in regards to Ssewanyana and Ssegirinya, they said these people are being produced to court, no matter whether it's just mention or even hearing. So how do these two conflict?
That is not correct. The principle is that if the director of public prosecution or his agent is satisfied that we have the evidence we need and the facts to prosecute these people for the crime they committed, you do it immediately. There is no other excuse.
No shortcut.
And no shortcut. And the question of bail does not arise. The only thing that remains for you to appear in a court of competent jurisdiction and be tried. No other excuse is possible or necessary.
Okay. Our viewers, we thank you to keeping it here, and we're trying to continue digging deeper into this entire discussion. In particular, we considered starting with the release of two honorables, that's Ssewanyana and Ssegirinya. Some year ago or thereabout, Honorable Abedi Bwanika was being castigated by his members because he suggested that it was high time the opposition sat with NRM and negotiated the release of the NUP members who were rotting in jail. Yesterday, on media, which I am sure you could have watched, he said if they had listened to me good time ago. Now that brings us to, to wonder on whether or not that would be a right strategy to negotiate with the oppressor to release your members in the event that you have failed to, use courts of law.
You see, it seems to me that you don't negotiate for your innocence. Whether claimed or not, you don't negotiate.
Is that possible?
It is out of place. You insist.
Prove
I didn't do it. You take me to court. The court is the one arbiter which will look at the facts and the evidence and either convict you or release you. So even for the benefit of the prosecution, on behalf of us, the people of Uganda, they can never negotiating for release from jail and giving bail or whatever. That is nonsensical.
What about where you have mistrust in the judiciary and there is room that once you negotiate, you will be released, so you avoid the embarrassment in the judiciary?
If the organ which is involved in the trial of suspects, you are suspicious of it, you let the country know. It is like a thief coming here today, and instead of raising alarm and calling the police, I say, please,
take
you
some
take
and
the
leave,
TV,
and leave the
but
chairs.
leave the chairs, that cupboard, take a few books, and leave the... No, come on. It is nonsensical.
Let's go back to because why I'm over insisting on to this is to ensure that you become empathetic enough so that the public can interpret both of us either right or wrong. You are in jail for more than a year. You are falling sick. You are not given any room to go and get medication. So would you still insist, people, no matter the case, let me stay there, prove your case? Or you'd rather say, I can assure you, things have gone so berserk, let me negotiate my way out and, and save my life.
When you are compulsory in jail, those who are keeping the or not allowing you to get bail are the ones who are guilty of a crime, of jailing you without recognizing the presumption of innocence, or that nobody is guilty until proved so by a court of jurisdiction. So I have never had anybody, unless they are mad, saying I want to negotiate to stay in the jail.
Definitely.
This is never heard of in human culture, to say, please keep me in jail. There is only one thing which happened during Idi Amin. Idi Amin was killing people. Whenever they released them, he would kill them. So one person I know was convicted of a serious offense, and he begged the court to jail him in order to escape from the murderous intentions of Idi Amin. But
it has also happened in your years, during the period of NRM. Myself and other colleagues, we had been granted bail at City Hall.
Yes.
And rumors circulated that they had deployed the people to arrest us. So we said, you'd rather remand us. Because later once they get you here, you have to go home. So your bail is so we say, don't pay our cash bail, will be remanded, we shall get a production warrant when we don't bail.
Because we are safer
inside the prison than CMI.
You are going to release us to us. I agree.
Okay, I'm taking you back to Jane Francis Abodo, the DPP.
Yes.
I don't want to assume that it was a political game, because when she was in Parliament, indeed I will quote her as she appeared in Parliament sometime last week. She said that because for them they were ready to proceed, they did not want to consider bail as a necessity at a time. And she said, now the bail question goes to the judiciary. Some analysts were trying to say and believe that because the DPP had washed her hands off the off the remand and the rest, that now it crossed to the judiciary. How do these two agencies contradict that one is ready and then is the other? The DPP was more or less indirectly condemning the judiciary, that in regards to the bail, it was their discretion.
She's right. I am told she's a former judge.
Yeah.
And on this point, she's right. When the prosecution says we are ready, then the court moves into the ball moves in the court of the court. So the court must say, since you are ready, we are fixing the 17th of August or whatever to hear this case. So once the prosecution says we are ready to proceed, then it is the court to say, we fix this date and this venue for you to hear, to be heard.
This other question, which you did not answer clearly, is about the expeditious trial. And I asked, and I continue to ask, how soon how long did it take you to have a specific capital offense had? Was it a week? Did you, because you said, like in Ssegirinya's case, it could even take a day and you either dismiss the case or otherwise. How long did it take you in your end of the trials?
Let me tell you, in one case I know, which was appealed against by the prosecution, the High Court judge had preliminary evidence from both sides and dismissed the case in less than half an hour. And she simply said, there is no case to answer here. Prisoner released. Less than half an hour.
30 minutes, a capital offense.
Then if it is, I was reading today, the saga about the national insurance, whatever you call them, Jauhanga and the Mong.
NSSF.
Yeah, if we hear about the corruption, which has been revealed in today's paper, I think it is Monitor, that could take a week or more, because you have to call all those witnesses who defaulted, who ate bribes, where the money disappeared. That could take even a month. So it depends on the facts and the circumstances of the case. If we go to court, Ssewanyana and his colleague goes to court, I hope next week, because there is no reason to wait.
Yeah, because DPP said they are ready. They
absolutely, absolutely. Next week it should be a trial. And then the first witness said I was lying. The big witness. I feared and I told lies. He's the first witness. And he's the principal witness. That ends the case. The judge will say, in light of the main witness saying he was bribed, there is no case to answer against the accused Ssewanyana and his colleague. You are here be dismissed. If the judge was very kind, he could even say, and I give you the costs of this ordeal. You've been in jail for so many months when you didn't commit an offense, and the main witness said he was lying, so I award you 500 million shillings for what you have lost. And let me tell you why judges do that. If you read in another newspaper, Ssewanya and his colleague have lost everything. Their investments, they have been closed. One of them was supporting a hospital.
Yeah, it was Ssewanya which was closed.
So that's why
Ssegirinya rather.
When you falsely accuse somebody and they are acquitted by the court should compensate the person who has been acquitted or whose case has been dismissed for lack of evidence. Yeah.
This previously I had some leftover of a question, for lack of another word. There were some two brothers who had been tried and convicted of murder. And these two brothers were, I think they were in either Mubende or Mityana. And they were convicted on circumstantial evidence. Years later, some pro bono lawyer visited them and then they made an appeal and acquitted. The question now is, when are you people as the judicial officers held responsible for your ill management of such cases? Like this trial judge convicted these gentlemen on simply circumstantial.
One should feel responsible, and I give an example of myself, where we made a mistake.
Yeah, like you can remember that case where you convicted some person on murder or something.
Yes, they gave me papers. Actually, I wasn't. We were I think
It was on
judges
it was
of
on
the
appeal, Supreme Court, yeah.
And the lead judgment was written by Sekoko. The High Court had convicted a man and his son
Of murder.
in somewhere in Bunyoro. Then, when I looked at the, we confirmed the conviction from the Court of Appeal, and we said appeal dismissed. Sometimes you are so busy, you make such a thing. Sometimes it turns out as time to us to be a nightmare. So I read again when I came here, and I discovered that when the police, they had the alarm from the victim. By the way, they were convicted of robbery, which was then a capital offense. The policemen gave evidence that they found them in the bed at home, sleeping. The father sleeping in his own house, the son sleeping in his. Shoes were dry. They had dust on them. But it had been raining the whole night. So my view was, we made a mistake.
If they committed robbery,
yes.
Which shoes did they?
Had they thrown them away and they jumped into the bedroom? So I was convinced that we made a mistake. So I consulted my colleague, who was Sekoko Mulenga, and the Chief Justice I will not mention because he's still alive. And they said, I think we made a mistake.
The evidence doesn't connect.
Yes, two of them said, Kanyeihamba, if we were to review every case, we would never finish our program. Once we have made a decision, it ends there. I did not agree with them. I wrote to the president, Museveni. I said, these two should be considered for clemency. They should be forgiven and even given compensation. I also wrote to the late priest, was called, he was a Roman Catholic man. He used to hate capital punishment. I think many people will remember him. But like Augusto or Augusti or something like that. I wrote to him and I sent him my file. I said, please plead for these people. In my heart of all hearts, I think they were innocent. And unfortunately, she passed away and he died with my file. Even today, I say, anybody hearing me now?
There are people who were convicted.
Yes.
Innocently
they were
by
from,
Supreme Court.
Man and son. I think we made a mistake. My conscience is not clear until I ever had the president give them
Pardon.
a pardon or something better happened on them.
But you people, Justice Kanyeihamba,
So we have a conscience
as Supreme
as
Court,
judges.
as Supreme Court, your principle is that you are it's the very court that can revise its decision.
That's right.
Did you convince your colleagues to revise your decision to that regard?
Yes, I told them.
And you said so. They said if you are to revise every file,
once we have decided we can't do anything.
So literally, save for an appeal. So as long as you have, now I want to put you in a category of you as judiciary, that once you have made a mistake, save for an appeal, nothing else can be done.
No,
you can't pay for your.
But that is not true.
You can't pay for your wrongs.
Again, I give you one of my examples. When we got a case, I think it was of robbery. This time it was correct. So the man who was appealing to us, the registrar mixed up papers in my file. So there was a letter saying he had died in jail.
Who had died in jail? The inmate.
They were
the accused.
Yes, one of the two accused. that he had died in the jail. So my colleagues, I think it was Mulenga, Sekoko, and Arthur, asked me to give the lead judgment. And when I was writing my judgment, I came to appellant number 1, where I had a note saying he had died in the jail. So I said, since the first appellant died in the jail, we don't pass any punishment on him. When we had a call for the accused to hear their judgment, he was
both appeared.
Had he kept quiet, that would have been the end of the matter. But he stood up, he said, "But I am here." So we quickly
revised your...
No, we quickly adjourned it into the chamber of one of the judges. We revised it. And I think it was Sekoko who said, this man, God must be on his side. So instead of sentencing him to life imprisonment for robbery, I think it was robbery, we reduced his punishment to 10 years. Judges are human, like me and you.
But you are overprotected.
So we can make mistakes.
Though with a lot of protection, that your mistakes end up punishing the citizenry. Like you are too protected.
Absolutely. Because the judgment from one high court judge
can even affect the whole village.
Often with the jury or assessors is appealable to the Court of Appeal, where the appeal is heard by 3 people. Then if somebody is dissatisfied with it, they have a third appeal, which is to the Supreme Court, the final one. If somebody is still dissatisfied, you can appeal to the president to exercise his prerogative of mercy, and you still can be released.
Which might take forever. We are breaking briefly, but once we return, we will definitely. I want to hear from you. Under which what circumstances does the DPP write that reply of no objection, but also of late the court assessors are no longer heard. I no longer hear them personally. We want.
Neither do I.
Yeah. So our viewers will be coming back in just a minute. Don't go away.
Alternative Digitalk. Real issues, real talk.
Fellow citizens, following the sequence of events, Uganda seems to be at political crossroads.
I'm not a servant of anybody.
Madam, I know the law.
As such, Alternative Digital brings you the Interface Show with retired Colonel Dr. Kiza Besuje.
Let's keep on the same page on Alternative Digitalk,
as he gives you the alternatives on the transition question, rule of law, human rights and freedom, youth inclusion in governance, economic stagnation, as he confirms.
I'll be always here Saturday from 10 a.m. in the morning. Be there.
Don't miss the live discussion on the Alternative Uganda, Digitalk TV Facebook pages, and the Alternative Uganda YouTube channel.
Are you craving for that special meal that will entice your taste buds and leave you with lasting thrilling memories? Look no further. Spice Island Bulenga has got your answer. Natural, fresh and delicious juice, the best meals. Don't miss our daily specials from Monday to Sunday. Pizza Wednesday, Saturday Pizza Bonanza, you buy one and take 2. Come dine with us and feel the experience. We are located at Prime Shopping Center in Bulenga, Mitiana Road. For inquiries, call us on 0704111720. Spice Island, we treat your cravings.
The alternative Digitalk. Real issues, real talk.
Our viewers, welcome back. For faithfully also sparing your credit to watch us. We believe that you pick a point or two and also send the message to the rest of the world for purposes of ensuring that there is good governance, justice, and constitutionalism. Most especially when we have a moving legal dictionary. By the way, he was taught by Lord Denning. You know, I read about Lord Denning and told that by the time he passed on, one of his legs was shorter than the other. I don't know what disease that is. Yeah. So we are with his student, a student of Lord Denning. Roger, when he hears of Lord Denning, he's like, is that even possible that you can get closer to a student of Lord Denning? So many people were wondering whether it is true. Anyhow, before I went into a commercial break, there were some concerns that I wanted to also have you elaborate about. One of the questions was, under what circumstances does a state prosecutor rise up and reply to a court, someone's bail application with a no objection? What circumstances can lead to such a...
You will find which objection?
Bail application, for example.
No, the prosecutors are the only ones really who should object to bail. Nobody else.
Yes.
And they object on a number of grounds, but the main one is they should present evidence.
Why they are objecting such a bail?
Yes, why they are objecting. Either the suspect is going to interfere or even more be dangerous to other citizens. That is the major one.
A second, Justice Kanyeihamba. The prosecution has, in so many cases, overused the word that the accused are going to interfere with investigations, even when you have nothing. I mean, in our cases ourselves, when they were objecting our bail, they said, myself and my co-accused that would interfere with the investigation. No, what do you exactly mean for purposes of our viewers?
I am also aware they abuse that power.
That excuse or something.
But for the judge, because the parties are appearing or they are being represented in a court of law where there is a judge. So the judge must either grant or refuse bail on his own judgment of the facts presented to him.
Not the mere excuse from the prosecution.
Not simply because somebody has said, I oppose bail. That person objecting to bail must present concrete facts and evidence as to why he's objecting to bail, and the judge must rule on them before it is rejected. It is not automatic.
A quick one. You are appearing in court as the prosecutor, and I am the accused. You raise your concerns on why I shouldn't be granted bail. Trial Judge A goes ahead and grants me bail. As a prosecutor, can you appeal against the decision of the trial judge for having granted me bail?
That's a very important question.
And And has it happened anyway?
Obviously, it appears.
Has it happened?
It has happened. Because the law says when one judge refuses bail, you can apply
Appeal.
to another. So that is the way it
But
happens.
it is silent with when one
Yes.
gives you bail, can the
Yes.
state run and challenge
But,
your bail application?
But also, the prosecutor must be allowed.
To also appeal against...
Supposing I am your brother and I'm a judge, and you appeal to Mr. Kadongo, who is not related to you as a judge, he refuses you bail. And then you go to your brother, me, a judge, and you say, can you grant me bail? Obviously, that objection, whether that would be wrong, because the judge would be biased. So if the prosecution can show, as many of our judges are biased, that you are biased, then the original refusal to give you bail, which you fear that challenge in that court, but you go to a friendly one, should stand.
But Justice Kanyeihamba, do we have a precedent in Uganda where a state has appealed against someone's bail application? Because I want to with your wisdom to guide the country, that at a certain point, one is granted bail, and then state runs to the higher court to appeal against such bail. Do we have a precedent in this country?
No, I don't have a personal knowledge of this happening. In most democratic
Or the rules are
countries,
silent?
yes. Once a court has granted you bail,
It's rare for states to apply
that
to
will be
appeal.
the last. Because granting bail is not saying you are not guilty.
In any case,
So they have another chance to present their evidence and everything when you are on trial. So granting bail is not extinguishing the accusation against you. It is simply saying you should be
temporarily out.
until the case has prepared itself and is ready to hear you. You must go and make out your case. So granting bail
Has nothing to
is
do with
not
the entire
an
trial.
offense. It's not wrong. It's the judge, and they are become a judge. You are interviewed and regarded as a good judge. So when a judge, in his opinion, looking at the evidence and the law and the gravity of the offense you committed, says, I grant you bail, it's not a matter for appeal, because you are not cleared. You have to go and answer the criminal charge, and the prosecution will be presenting their evidence against you. So nothing is lost.
Okay, our viewers, we are with Justice Kanyeihamba trying to, of course, dig deeper into, lots of issues today. Before we went for a short break, we're trying to ask also from you, first of all, where did we get the concept of the court assessors, their purpose, and literally why they are not so much heard, apparently. The ones I heard that were prominent were in the case of Uganda versus Draru in Kazini's murder. And they came and gave their assessment, and literally it was like, I think the case was more or less reduced from murder to manslaughter. And I wanted to ask also from you these questions: where did we get that concept of the court assessors, their effectiveness in Uganda, and also on whether their findings or assessment is really, does it compel, can it be followed by the trial justice?
The first point we have to make is that the judge is not bound by the
Decision
assessment, but by the verdict of the assessors. He's not bound. They can say, For us, we say guilty, but because he's trained in the evidence and laws, he can disagree with them and said, I don't agree with the assessors, the man is innocent or is guilty. And that has happened many times in Uganda.
In a second, before you answer that, let me add this. Can I appeal and also attach the assessors?
No.
Because I would perhaps, anyway,
No.
I mean, any person would think.
When I was in, when
I would
you
appeal
used
and
to
attach also and
practice
say,
law,
but to know,
you don't appeal.
and also and attach the grounds
Yes.
for the assessors.
And that's why we said, let the judge decide. Because the
Not-
judge knows the law, has been presented with the fact and the evidence. So where he thinks the assessors are wrong, he comes up with his own verdict that in his opinion, her opinion, she disagrees with the assessors. The man is innocent or is guilty. That prevails.
Tell us where you
They
borrowed
don't
the,
appeal against it.
where you
But
borrowed
you can
the,
appeal against the judgment.
not,
Not that
depending
he
on the
refused-
assessors.
He refused the advice of this there.
Uh-huh.
But you had asked me where it came
Yeah.
from. I think it was in the year 1100,000 after the birth of Jesus, that the judiciary and people of Uganda, or rather the people of Britain, were not in agreement. There were clashes, they didn't agree with the verdicts. And the people rebelled, and they said, we shall only accept the judgment made by our peers. Peers means people who are equal to you. If you are a peasant, the jury should be consist mainly of peasants. If you are a doctor, there should be some nurses and doctors in this assessment. So it was that nobody is guilty unless his peers or her peers have given assessment of the evidence as well. So it is a verdict of your ordinary citizens, your friends and the neighbors. And if they say you are guilty, normally the court will say, I agree with the assessors that he is guilty as charged. If they disagree with you, he can, and say you are innocent, he can also still agree with them that I agree with the assessors that the accused is innocent. But for him, he has the other responsibility to assess the evidence presented to court and the facts, and they say, I disagree with the assessors. I think the accused is guilty. That is how
So is it, so who appoints the assessors in such courts?
in the UK, they are appointed by people like we would call the LC chairman, the local committee when the case is being heard, say in Mbalala. There would be people, easy peers would be in Mbalala. Farmers, shepherds, those are his
Does
peers.
that mean there are no
So
permanent
it
assessors?
is, the members of the jury are nominated by the local authority, saying it loosely. But the prosecutor is entitled to object to up to half of the jurors by saying, no, I don't want Norman there because he is the brother of the accused. I don't want Kanyeihamba there. He is a lawyer. Lawyers are not
Supposed to be assessors.
rather are not qualified
To be assessors.
Assessors. I don't want this other man. When I appeared before him in another case, he was against witness against me. Those are valid reasons.
So is it mandatory that every such capital, trials
in
of
the
capital...
UK, there are certain capital offences, certain civil cases where it is mandatory that the jury must be empaneled to assist the judge.
Are they
in Uganda, I don't think there has ever been
mandatory.
Yes. And secondly, because of the way we are governed and we look at authorities, if President Museveni said, I swear I saw it, the jury might say, this is our boss, we must agree with you. So that should be absent in the system of the jury. So even I, in Uganda, I was always opposed. As a lawyer and a judge, I was always
opposed to the assessors.
To having assessors.
The Anani lawyers in the first place, how could they even assess such sensitive cases?
No, they can facts. Facts, lay persons who are assessors can judge facts and say,
this is wrong,
this young boy of 9 could have not been responsible for impregnating this old woman.
But with our levels of corruption, I'm imagining if you had assessors in Uganda, how they would their verdict
they accused and Mafiti would bribe them.
After Ming, you first bribe the assessors before you run to the trial judge.
That's why, for me, personally, I objected to them in Uganda. Even in the UK.
What does the law say? Do we have them literally in any of your rules or something? How do they come in Uganda? Literally, what?
I think
which law rings them?
There must be a rule. We can look it up.
Okay.
Saying such and the court may empanel assessors. I don't think they have been abolished. So, but they are hardly used
in Uganda
because of the controversies surrounding their behavior and conduct.
So are they pro bono officers? Are they paid or they are?
I think they are paid some allowance. Not as the one we've been reading today about NNSF, but a small amount.
Okay, our viewers, thanks for keeping it with us. I have another question for you here. We want to, in the event that there are some comments which might come on board to also substantiate on what we have already discussed, we shall definitely read through and then Justice will reply. I want to ask you in regards to East African community.
Yes.
Which to many it was collapsed by General Amin when he said Nyerere was his wife and he said we could even meet in a ring and fight. To many now, I think there is a biggest problem with Uganda in regards to antagonizing the East African community. Previously it was Amin. Apparently Congo says Uganda and Rwanda now are poking their nose into the internal politics of DRC. Yesterday, if I'm not, yeah, it should be yesterday, there was a sitting here of East African Legislative Assembly. The Congolese MPs that represent Congo in the IALA boycotted. They flew from Congo and rather landed in Nairobi and they delegated, they deliberated on Zoom. When they interviewed the Speaker of Parliament, of the IALA Parliament, he said that their defense was that their government accuses Uganda over the conflict in Congo. Where does this leave the East African community? That's one of the questions. But also to ask you, did we rush to have DR Congo and South Sudan to be part of the East African community?
You know, that is the $64 question. I have mixed feelings. When I was a student in the UK, I was elected and I worked for some years as the president of the East African Students Association. And we were all campaigning very hard for the establishment of the East African community. But before the came in, we already had a conflict in the community itself. Uganda and Rwanda were not seeing eye to eye.
Rwanda and Burundi also had issues.
Then Rwanda and Burundi were not seeing eye to eye. Secondly, one of our police big man was accused of supporting Rwanda. So these conflicts
have always been
were not started by
the
Congolese Republic. They were already there. Many people didn't know that Tanzania and the Kenyans are much closer
than any of us.
Than any of the others.
Is it because of the language?
Ruta now, who is the president, who is making changes, seems to be a friend of our president. But his son, General, has said he can defeat Ruta and the Kenya in 2 weeks or whatever. Not knowing that in East Africa, the darling of Europe, the mistress of England and the Germany is Kenya. What my friend Mohammed doesn't know is that if he stepped on Kenya soil, the British army would be here,
and
the German army would be here, even the American would be here, and he would be defeated in 1 hour or less. We Ugandans say many things without knowing the implication. I am sure the Constitutional Court of Uganda, headed by Egonda Ntende, didn't know the consequence. They will be committing treason if they said President Museveni is above the law and the God, not remembering that any president of Uganda, when he's being sworn in, he swears under the presidential oath, which says, in the name of God.
And also respecting the Constitution.
You see, there is a saying in the law that telling half the story is a lie. You ask in Uganda today, there are almost thousands who think that the president is above the law.
Even his ministers.
And they quote the section which says, as the president, sovereign president of Uganda, Museveni is above the law.
Cannot be
and
so.
I agree. But they forgot that Caesar Besigye has sued him 4 times and lost them. But the party, one of the parties was Museveni. They forgotten Kanyeihamba has defeated him on 3 occasions when he nominated the former Chief Justice Odochi, and they brought him to court and they won the case. They are all right, including lawyers. I have met one of them today who is going to swear an affidavit confirming that the President Museveni is not above the God or law. I defeated him when he nominated Odochi, and I personally led the team we defeated him.
So in line,
So
Congo,
on Congo,
Congo, yeah.
you say where we
Yeah, did you rush?
premature
Yeah, to invite,
admit
yeah.
him. I have the feeling in my mind of an old Muchiga man. I come from the Bachiga of Western Uganda. And men are not supposed to interfere in the chicken, in the kitchen, where the wife is cooking. So he came home very hungry. The wife was somewhere, and he dipped his hand in the cooking pot and removed a very hot piece of meat and put it in the meat. And then it was burning his mouth. And then he said, huh, shall I spit and spit sweetness, or shall I swallow and swallow fire?
Mire
That's how I feel.
mire murro,
Yeah.
mwere nchero bunuzi.
So that I feel the same.
This is what is happening in the
about,
African community now.
The Democratic Republic of Congo on admitting her. I knew we would have problems. Either to those we had with Rwanda, with Burundi, very little with Kenya.
Even South Sudan.
Yes, even South Sudan. But you also wanted us very badly to be a federation, because we would work together and be more successful
As a
united.
block, as a big block.
Yes. So I was a typical Muchiga who says, shall I swallow fire?
Or spit
Or
the sweetness.
spit and spit sweetness. I don't
How
think
can this
we
be
made a
managed?
mistake.
To invite, to admit DR Congo and...
That's right. I think we are right to admit these countries. Maybe they will help us to solve these problems. Even now, Congo, the latest member of the community, is the one that's choosing Uganda of being indisciplined. So these are teething problems. I don't want to oppose the Federation of East Africa, but he will only come when the president of Congo and of Uganda and Ruta, who seem to be complacent, have left the siege of politics.
But you see, this is Kanyeihamba, what confuses all of us, especially young people, for lack of another word, is that there seems to be that exaggerated sense of entitlement amongst either Ugandan leaders and Rwandan leaders.
Yes.
Like literally Mr. Museveni I think he's the most experienced in the region, and perhaps he wants to build the head boy of the region, and so is Kagame. And then you wonder, can't we live minus going to Congo? Can't we, I mean, mind our lane as a country? Either
I entirely agree, and for me, I am resigned to the position that we, the modern generation, which including Museveni, Ruta, and all now, we can never bring Federation of East Africa in place. We are leaving it to you and your children to do the necessary.
But one of us, in regards to the generation, says he can attack Kenya in a week. Anyhow,
Among the youth, including that one,
now you see,
they are also what we call dreaming and thinking aloud on what should happen, which will never happen. I am very old now, 83, although people say I have a 80-year-old, including you, mind, and I think my mind is very perfect. But I don't know why people don't philosophers on these issues. A friend of mine misbehaved and messed up Kigezi Bank of Commerce. The Supreme Court of Uganda has held that the shares of Kigezi Bank of Commerce should be returned to the owners. But my friend is mine. Then several of us, including General Muhozi and Professor Suruma Ezra, we took Nzei and others to court for stealing our bank, which they called National Bank of Commerce. When I went to check recently, National Bank of Commerce is nowhere to be seen in the register of Uganda Bank because it was sold. But he called me after they refused to answer our petition, and the court heard us and ordered them to file their responses defense. They didn't. So they are choosing or contempt of court. But can you believe it? He asked a friend of mine to ask whether we can settle out of court. How can you settle out of court when the court has said we shall give judgment on the notice? It's too late.
I have a few comments here that I want you to perhaps reflect on. There is the name is Artful Doja. I believe it's not in Uganda. Okay, believe it or not, Uganda would be one of the best countries if those who embezzle funds were stealing only 40%, like in other so-called democratic countries. Then use the 10, and then use the 10% of that to own the media and dictate what to be published. His view is that if they could only steal 40%,
there is wisdom speaking. I agree with him.
If they could only steal 40%,
you need to read to today's paper to see what has been stolen in NNSF, and then you see who has stolen them.
The
money being given without security, billions.
Ngwenya says, Ugandans, don't be misled by these old people to your information as for information they are still in service. However, they say that they are retired. They are not. They still work for dictator Museveni, and he mentions your name like Justice Kanyeihamba, Kale Kayihura, and many more. They are still in touch. You watch them. Sometimes they come out as they claim for their money. Behind all, they come with a lot of diversion. Oh, we are watching.
Yeah,
definitely.
Can I talk to him?
Yeah, he's a rock.
Since I became since I became a public figure in Uganda, I have constantly accused the NRM, led by Museveni, to be corrupt, to be abusing. I have taken them to court 4 times. So let him answer me. Where is Kanyeihamba working for Museveni?
I'm adding his comment also. He says, the way Mr. Kanyeihamba never, the way I see, that is him. He's called Rock Ngwenya. The way I see Justice Kanyeihamba, it's like he never got his pension. They know themselves how they divide money for themselves, selfishness, and they have destroyed our country. To him, it's like with such people, retired people like you, come with such vigor as an indirect demand.
He's entitled to his view as a free person, but he's absolutely wrong about me. His comment may apply to others, but if you see my record, since I became a public figure. What is his name?
He's called Rwgards.
Mr. Rwgards, you would entirely agree with me. But if you are opposed to the wrongs that are happening in Uganda, then you are with me. But if you think I am part of that problem, you are absolutely wrong.
John Wansolo Mwanda says, Professor has been a good Ugandan and has always stood for the truth. My father worked under him when he was Minister of Commerce. There's some comment here. I don't know how it disappeared.
Thank you, sir, Mr. Mwanda.
How it disappeared, but someone had said that in other countries, presidents appear in parliament and answer tough questions. Why didn't you provide that in our constitution, that save for the State of the Nation address, where he comes and he gives us his view? In some other countries, presidents come and appear in parliament, and then it's like a question and answer.
I used to, until the end of the day, ask Mbabazi. The last meeting I went to address parliament, Mbabazi was the prime minister and he presided. That is about 5 years ago or more. I used to address parliament regularly. Whenever a new parliament appeared, I was invited by the clerk together with the sitting prime minister. I was invited with the Rwanda was the prime minister. I was invited when the late Apple Simbambi was the prime minister. I was invited when the late Adebo was president to address parliament, because they think I have something very important to address every parliament and even addresses regularly. The other time I addressed parliament, Museveni had called the speaker, the former speaker of Kenya, to be our guest of honor. Museveni is the one who invited us, me, and Professor Oroko Nyango to address parliament.
I have your last question.
But they no longer do.
I have your last question. Bearing in mind that you led the African Court on People's Rights, as far as I know, you could be aware that the United Nations High Commission on Human Rights closed in Uganda. Where does that leave Uganda, and especially the opposition whom they beat Chiboko every day?
It is a very sad commentary on the impunity and disregard of constitutionalism that the current governance has brought upon the name of Uganda. That news is terrible for us. I mourn for Uganda. It is clear evidence that the rule of law and justice, as we know it under democracy, are now in a deep coma, near death. We need emergency of government to restore them. The NRM under Museveni will never, never resuscitate the rule of law or justice in Uganda. Never. I swear it. And I'm a Christian.
Your last word in seconds, and then we shall leave here. Most of the questions that are pending, we shall carry them on up to next week.
Yes, please.
Because there are many. So your closing remarks, just in a second or two, and then yeah.
I ask everybody, in light of what is in today's newspaper about NNSF, Byarugaba, and among, please pray for the power of Africa. We are in very deep, deep trouble. And our justice system, the rule of law, are in a deep coma. of illness.
I will close with the title of your book, In the Power of Africa, The Unexpected Happens. God bless all of you people. See you in the evening. We will be you join us in our Afro-Caribbean show where we shall be hosting Mr. Rickford Back. He's an exilee of Guyana's government. Guyana as a country. He's an opposition member, but based in the States. So we shall host him today at 7 p.m. Ugandan time, and Washington DC time is going to be 11 a.m. May God bless all of us for God and my country.
Alternative Digitalk. Real issues, real talk.